Welcome back to this final segment in this law session of English legal system, of course dealing with the role and operation of courts. Now we have covered a fair bit of ground, and in this final law session there are a couple of things I want us to do. I want us to finish off by looking at other types of adjudicating bodies, certainly looking at other courts as it were, but not technically a court. I'm speaking of course of administrative tribunals. We'll spend a little bit of time on that. We will look at other types, other courts as well, and the impact that they have on the UK. And finally, I want us to look at judicial decision making and certainly how that impacts on, for example, this whole concept of precedent. So when we look at the role and operation of courts, it does involve knowing how judges deal with the cases before them. When we look at administrative tribunals, there are numerous. They control a vast range of activities, from the issuing of passenger licenses to airlines, through to employment tribunals, to adjudicating on parking fines, social security entitlements. Now, most of these tribunals have their own rules of procedure, and they are generally regulated by specific statutory controls. Now, no tribunal have ever been created at common law, and the majority have relatively little contact with the traditional courts, though there is a right of appeal from some important tribunals which exist either to the High Court or to the Court of Appeal. So for example, appeals from the Employment Tribunal go to a specialist appeal forum known as the Employment Appeal Tribunal, and from there any appeal goes to the Court of Appeal. Now, a similar framework operates within the immigration tribunal system. Now, most of the tribunals were put on a standard footing. So when you look at the whole tribunal service, it was standardized, and you will find that when you look at these chambers, there's the lower chamber and the upper chamber, they are all structured now in somewhat similar fashion. We are going to come back to tribunals, but I want to just touch on the other courts before we then flesh out the whole tribunal situation. If you look at the other courts which have got some impact on the UK situation, of course, you start with the European Court of Justice, now as it is known, the Court of Justice of the EU, same thing, change of name. Well, when you look at this court, it is the final authority in relation to the interpretation as it relates to points of EU law. It is not a court of appeal, but it is a court to which domestic courts can of course refer points of EU law for clarification and ruling. Now, it is interesting because in this whole discussion we're doing as it relates to courts, their role, their operation, if you refer a matter of EU law to the Court of Justice of the EU, you do so by way of what is called an Article 267 action. It used to be called Article 234 under the renumbering of the treaties under the TEU, the Treaty of Maastricht, but now under Lisbon and the TFEU, the Treaty of the Functioning of the EU, it's been renumbered to Article 267. Now, a court or a tribunal can refer a matter for clarification to the Court of Justice of the EU. Now, when I said it was interesting, what I meant was that what is considered a court or tribunal within the framework of this whole law session I've gone through may actually differ from the definition of court or tribunal within the context of EU law. So as we've spoken about court or tribunal here, I have not, for example, mentioned let's say the body that regulates doctors or the law society that regulates lawyers. For the purposes of the framework within the UK, they're not necessarily considered courts or tribunals. But for the purposes of making some sort of reference to the Court of Justice of the EU, they may very well be considered and defined under EU law as a court or tribunal. Now, the other court to consider is the European Court on Human Rights. It is an international court which was created by and with the power to adjudicate cases which involve the application of the European Convention on Human Rights. It is a totally separate institution from the Court of Justice of the EU. The Court of Justice of the EU looks to the Treaty of Rome, the 27 member states within it, and it deals with EU law. When you look at the European Court of Human Rights, it looks at the European Convention on Human Rights, and it looks at the signatories under the Council of Europe, and that is what you consider. It's a totally different thing. The other court, to, of course, bear in mind, is the Judicial Committee of the Privy Council. Now, it has a number of esoteric functions within the English legal systems relating, of course, to matters such as admiralty cases, appeals from disciplinary decisions of, say, the General Medical Council, and its jurisdiction has certainly extended to include adjudicating on the legislative competence of the Welsh Assembly and the Scottish Parliament on the procedures which are laid down in the Wales Act 98, Scotland Act 98, respectively. Now, as a relic of course, its imperial past, Britain certainly considers that when you look at the function as the final court of appeal for cases from a number of Commonwealth jurisdictions, the Privy Council, of course, has jurisdiction over that. Together, of course, when you look at certain English cases, the Privy Council cases may very well be authoritative. When you look at it, they're not the authority within the hierarchy of the court structure, but they may very well be very persuasive authority. Because when you look at the Privy Council, the idea is that it is the same law lords who sit in the Supreme Court who also sit within the Privy Council. That therefore means that you're looking at the same people looking at an area of law which may very well be very important within the UK, and so when they come to sit as the House of Lords, they can of course look at those decisions which referred to, for example, another jurisdiction within the Commonwealth. Well, I promised you would come back to tribunals, and this is it. When you look at a tribunal and its adjudication versus, say, alternative dispute resolution, as I've flagged up, the use of specialist tribunals can be used to resolve disputes across a wide range of issues. Now, tribunals have had a long history within the English legal system since the Second World War between 1939 and 1945. They are important in the court system because of the quantity of cases which are handled by the tribunals and because of their distinctive procedures and methods of adjudication. So for your purposes, you will be required to understand the general aims and objectives of tribunal and ways in which they differ from the traditional civil and criminal courts. Now, if you look at the difference between courts and tribunals, well, tribunals are established by Parliament. The common disputes are those between individuals and generally either government departments or specific matters for which they deal with. So when you look at the Social Security Tribunal, it deals with issues between individuals and the Department of Social Security. So if you're looking at a benefit, it may very well be that you have an issue that then is taken before the Social Security Tribunal. In the case of Attorney General and British Broadcasting Corporation, the House of Lords said in 1980, the essential difference between a tribunal and a court is that a tribunal does not administer any part of the judicial power of the state. It has specific jurisdiction as allocated by Parliament and does not enjoy a broad jurisdiction defined in general terms. Now, the chairman of the more important tribunal is usually a lawyer who sits with at least two lay persons, typically people representing the sort of interest group which is familiar to the parties and the issues which are before the tribunal. So you might very well find that you have a very experienced employment lawyer sitting as a tribunal chairman with maybe people who are in human resources being the two lay members. Well, there are some criticisms, there are some advantages, disadvantages to using tribunals. There's the issue of the lack of legal representation. There is this more informal approach in the tribunals. The fact that you don't have legal aid may very well be a criticism. Most persons either represent themselves or they rely on friends, members of law centers, other interested groups, for example, some certain advocacy groups. What we have seen, though, is that the tribunal structure has been unified, it is structured, and we see that the service now taking the most of the tribunals that deal with matters, with specific matters. Arbitration, as an aside, we have to take on board arbitration as well when we look at the context of the court structure, because arbitration is the commercial world's response to the shortfalls of the traditional court system. Usually, there are disputes between individuals and experts in a subject matter, and what you generally get is some sort of specially trained lawyer sitting who's been nominated or agreed to be the arbitrator. And in contrast to, say, a court where you have a judge, the arbitrator tries to effect a settlement between the parties, and the needs of each party is looked at in order to achieve a fair settlement for them to succeed. Now, we're going to end on looking at judicial decision making and the stabilization of the law, because that is critical when you're looking at what the court's role is and what they're there to do in terms of their function. Well, in carrying out its judicial function, a number of factors will influence the decision making and how the judges determine what is before them. They will look at weighing the factors as it relates to a particular case. What do these factors include? Well, the need for stability and certainty in the law, the wish to do justice to both the parties, the need not to usurp the role of Parliament, the need to justify a decision by reasoned argument. That's why sometimes when you see a decision not being followed, and certainly again, I would urge you to look at the precedent law session. The idea is that a subsequent court may resile from a decision because it was per incuriam, meaning it didn't take on board all of the arguments that by law it should have. The need to base a decision on at least one of the issues raised by the parties. So when you look at judicial decision making, these are the factors which come to the fore. Now, although judges are required to perform many tasks during the course of legal proceedings, when considering the judicial function, attention is usually focused primarily upon the way in which judges determine disputed questions of law. What we're talking about here is how do they adjudicate? Well, in arriving at their determination, courts are expected to be consistent with decisions in previous cases and to provide certainty for the future. Now, these requirements are reflected in the English legal system as it relates to the context of judicial precedent. Statute binds judges because of the doctrine of separation of powers as well as legislative supremacy. Case law is binding because of the doctrine of precedent and stare decisis. Judges are expected to decide like cases the same way. Now, if we look at the development of the common law through this whole precedent issue, when we look at statutory interpretation, what we see is that a ratio of a case, meaning the basis of the finding of the case, will more or less be determinative when we are looking at subsequent cases. What I would urge you to do now, though, is that now that we've looked at the physical structure and now that we've considered some of the important aspects of the role and function of the law, is either return to the judicial precedent law session, or if you haven't done so already, that may very well be the law session to listen to now, because in that you will see how exactly the judges themselves operate. Concurrently, I would also say to you to ensure you listen to the law session in relation to the judiciary and the magistracy to see who are the players in the system. That then brings us to the end of this law session on the role and operation of the courts.